Offer to purchase Part 3, starting in line 220. These are our final clauses in our signature area where we go from making an offer to becoming a binding contract. Starting with line 220, we have a disclaimer about Megan's Law. The seller warrants that the seller has disclosed to the buyer all notices that they've received from the local sheriff's department pursuant to Ohio's sex offender law. And buyer acknowledges that any such information may no longer be accurate and agrees to inquire with the local sheriff. And also they agree to rely solely on their own inquiry with the local sheriff as to registered sex offenders and not the seller or any broker or agent. It's a protection for us. Now in line 223 we begin with the condition of the property. The buyer acknowledges that they have examined the property and agree that the property is being purchased in its as-is present physical condition, including any defects disclosed by the seller in the Ohio Residential Property Disclosure Form. That's why when we were making the offer in Part 1, we said anything you've seen or has been disclosed, if it's important to the buyer to have it fixed, include it in the offer. Don't wait for inspections. Another thing that's important to know, occasionally you have a buyer, an investor sometimes, or a buyer who's out of state who's relying solely on your viewing of the property. They have not seen the property. Make sure you cross this language out that they have examined and make it buyer has not examined the property and this offer is contingent upon the buyer's inspection. Because right in our offer we say that they have looked at the property. Never a good idea not to see the property. And also as a buyer's agent, remember if you are working for a buyer who can't be there and they've asked you to video or take pictures of the property, know that you must have the seller's permission. So ask the list agent, am I allowed to take videos? If the answer is no, you cannot take videos. Now, going on with this, the seller agrees to notify the buyer in writing of any additional disclosure items that arise between the date of acceptance, the date the buyer and seller agree to all parts of this offer. The buyer checks whether they have received a copy of the residential property disclosure. Hopefully they have, and here you will put the date on the residential property disclosure, the date that the seller filled it out. If they have not received, understand that Ohio law for property disclosure says if a buyer hasn't received the property disclosure when they're making the offer, they then can change their mind for any reason at all, right of rescission for the next 30 days. As a listing agent, make sure the property disclosure is available when you list the property. We all know of many instances when a property is listed and goes under contract within hours or a few days. Make sure you have that before you list it to protect your seller. And in our brokerage, if for some reason they are exempt from filling out the form, make sure that property exemption form is there. It will protect your seller from that right of rescission. This goes on to say it's subject to the seller completing the form if they haven't done it within the next number of days. Also in this paragraph, the seller agrees to pay the cost of any repair of any gas leak found between the street and foundation at the time of the transfer of utilities. They also agree to comply with all local governmental point of sale laws. Do your due diligence for your buyer, however, and know if this is a point of sale community. If it is and the point of sale has not been done, make this offer contingent upon the seller providing the buyer with a completion certificate showing all violations have been cleared. Seller will promptly provide buyer with copies of any notices they receive from governmental agencies to inspect or correct any building code or health violations. If applicable, buyer and seller shall have X number of days. Fill in the amount of days after receipt by buyer of all notices to agree in writing which party will be responsible. Will it be your buyer? Will it be your seller? In the event buyer and seller can't agree in writing, again, we will sign a mutual release, and this is null and void. We have built in the walkthrough addendum. We also have an addendum if you want to use that too. But the walkthrough, say that the parties agree the buyer may conduct a walkthrough of the property on or about days prior to the date of title transfer. Actually, you want to be sure your buyer walks through before escrow, before they sign their mortgage and other escrow documents. Why? Well, if something is wrong, the buyer has no leverage if they've already brought their money in. What might be wrong? Well, let's say there was that beautiful crystal chandelier hanging in the dining room that you included in your purchase offer, and when you do the walkthrough, it's gone, and the 1999 ceiling fan light special from Home Depot is hanging in its place. The buyer wants the crystal chandelier or its equivalent or the monetary compensation. Make sure that's all included there. Another suggestion, if the seller is staying beyond title transfer, and we discussed this in part 1, but I'll remind you of it here, fill out the seller occupancy after title transfer and be sure to include a second walkthrough after the seller has left but prior to possession by the buyer to make sure there is no damage. Many of our agents are asking that the escrow agent withhold an amount of money to cover any potential damage that will be released as soon as that second walkthrough is conducted. So, if there is a material adverse change in the property's condition at the time of the walkthrough, the buyer shall promptly notify the seller and the escrow agent in writing. Thereafter, the parties shall mutually agree in writing upon an amount to be either held in escrow from the seller's proceeds pending correction of the material adverse change or credited to the buyer through escrow at the time of title transfer. Before you choose one of these, check with the buyer's lender to see which way they want it handled. We then go into representations and disclaimers. Many agents skip over this, don't feel it's important, but it's extremely important. In this paragraph, the buyer acknowledges that the seller has completed the residential property disclosure form and agrees to hold the brokers and their agents harmless from any misstatements, errors, or omissions made by the seller. The buyer also acknowledges and agrees that the brokers and their agents have no obligation to verify or investigate this information provided by the seller. Buyer has not relied on the representations by the broker and or any agents regarding the use or condition of the property, square footage, zoning, lot dimensions, homeowner fees, public and private assessments, utility bills, taxes, or special assessments except as listed below. If none, indicate none, and we expect to see the word none written here. If you have made any promises, you're supposed to disclose them, any representations. Oftentimes there's nothing written in these lines, and the instructions are right here. If none, indicate none. Lines 257 and 2 through 260 explain what happens if there's any damage to the property from the time you go under contract until title transfer. What could happen? Well, we have storms here in Ohio. Branches come down. Foundations leak. Gutters get plugged up. Windows are broken with kids playing baseball in the backyard. Whatever it is, make sure your buyer understands this section. So if improvements to the property are destroyed or damaged in excess of 10% of the purchase price, in our case, we have a $200,000 purchase price. That's $20,000. If this happens prior to title transfer, the buyer can do one of two things: accept the insurance proceeds and complete this transaction, or terminate the agreement. If there's a catastrophic fire and the house is destroyed, the buyer may not want to wait for the insurance and the rebuild. They may say, sorry, that's it. If a house goes away in a flood, any number of things could happen. If that's the case, they'll receive the return of all deposits made. That's your earnest money. If any damage is less than 10%, the kids are playing ball in the backyard and break the picture window. That's not going to be a $20,000 repair. Then the seller shall restore the property to its prior condition. Put your listing agent hat on for a second. If there is any damage, make sure that you notify the buyer's agent. Hey, listen, the kids were playing in the backyard, broke the window, we are replacing it, so that they're fully aware. Lines 262 through 268 discuss that this is now a binding agreement. Days are calendar days. Acceptance occurs when the latter of the parties signs this agreement without making material change and then delivers either written or verbal notice of such signatures to the other party or the other party's agents. We do say verbal here. Court cases have said it needs to be in writing, but understand that once you've accepted, you've accepted. Upon acceptance, this offer and all attachments and addenda become an agreement binding on buyer and seller. We call this a contract. No longer an offer, now it's a contract. And it's binding not only on the buyer and seller, but their heirs, executors, administrators, and assigns. This agreement shall be made part of or be used as the escrow instructions and shall be subject to the escrow agent's standard conditions of escrow, not inconsistent with the terms of the contract. The terms, covenants, conditions, and provisions of this agreement to be performed by seller shall survive delivery and recording of the deed. So even after title transfer, the seller may still be responsible for things they agreed to make sure were done. We now have a checkoff of the addenda. It's important that any addenda you have are noted here for the simple reason they become part of the contract. Of course, you must have the agency disclosure. That's required by Ohio law. Hopefully the residential property disclosure form. If it's a VA FHA loan, you must have one of these checked. If it's a condominium, then use our condominium addendum. If you've added to a separate walkthrough addendum, mark that. If it's a house sale contingency or concurrency addendum, make sure you've noted that. If it's subject to lead-based paint, that was there, check that. Until we redo the contracts, you will be always adding in here earnest money, if indeed you collected earnest money. The terms and conditions of any addenda supersede any conflicting terms of the agreement. So the addenda are extremely important. Now, your buyer is to sign with their legal name. We like to see the address, email address, telephone number, because this is how the escrow agent knows how to reach them. Be sure it is dated. If they are signing wet signatures, do include a date. The date is extremely important. If they have made an earnest money deposit, you must complete this section. A check made payable to either the broker or escrow. Did they give you a check? You will check that. If it's a note, you will check that. And then you, as the agent, will sign right here. Our office will be KW, Greater Cleveland, Southeast. And then you add your phone here, the agent's phone, so where they can reach you in case there is any questions. Now, acceptance. This is the seller's part, but it's important that you fill this out. If you have the listing broker's address, put it in there. And according to the MLS offered in the MLS 2, you have to put our agency down here. So, my spelling is bad today. Keller Williams, Greater Cleveland, Southeast, and our address is 32875 Solon Road, Solon, Ohio. Make sure that is all filled out. That's where they're going to send our commission. Actually, I read ahead. You put the broker's name here and the address down here. 32875 Solon Road, Solon, Ohio 44139. It's a good idea for MLS purposes to put in your selling agent's name. So this will be your name, your license number right here. The selling broker is KW, Greater Cleveland, Southeast. And our broker ID number for the MLS is 9181. Congratulations, you have completed an offer to purchase on behalf of your buyer. Now it's time to get contract to close.